right, we will call the Board of Appeals meeting to order at 7:35 on February the 9th. I'd ask that you'd stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, procedurally on our agenda tonight, we have two excused absences, Ms. McIntyre and Mr. Kusha. Next on the agenda would be the acceptance of minutes. There were draft minutes provided from the January 12th meeting. If there's any discussion?
I'll make a motion to approve. No discussion. No discussion.
I'll make a motion to accept the minutes.
Second?
Motion and a second. All in favor?
Aye.
Okay, we'll declare those approved, and then if Alan has any comments on them, the next meeting, we can always revisit that. As to the committee reports, I don't think there's much to report on that, considering Ms. McIntyre is sitting on those committees, so we have to table that until the next meeting. So next we have a request for a hearing for a variance from the petition of Smolak Vaughn and of a consultants on behalf of Suzanne Wainwright, trustee of the Technical Training Foundation, also known as Technical Training Foundation Trust, for property located at 1665 Great Pond Road, map 2, parcel 9 in North Andover. The applicant is requesting a variance pursuant to section 4.136.3.C.II.3 for construction of a new permanent structure in the R1 zoning district. So before we begin, Mr. McLeod, I just want to you had done, several years ago, you had done some work with me in the past as an engineer, and we don't have a prior business, we don't have a business relationship now, but you had done some work for me in the past. Just want to make that disclosure, and if to the extent you'd like me not to sit on this hearing, I'm happy to recuse myself.
It's going to be 5 years ago, so I don't have a problem.
Okay. All right. Counsel?
That's fine by me.
Okay.
You paid your bill, I hope.
Well, I don't think it was, I don't recall, but I'm assuming that, you know, we're okay with all that. I understand you're being funny. Don't recall. I think it was actually an LLC you were working for us.
I don't recall, but it was a while ago, Al.
All right. Well, you know.
And I don't think that would influence your decision, so I don't have a problem.
No, I just would like to dispel any, appearance of impropriety just before we start a public hearing. So, and procedurally before we start, so we do have 5 members here tonight. So it's a 5-person board. It does require 4 votes as a supermajority for what you're looking for. We do have alternate members that are going to sit here tonight and hear it. Mrs. McIntyre and Mr. Kusha are the regular members of the board, so they could always rehabilitate and come back to the extent that there's another hearing as well. So I'm assuming you still want to go forward with the way the board's comprised.
We'd like to move forward tonight.
Okay. All right, so maybe we can, Scotch?
Notice is hereby given that the Board of Appeals will hold a public hearing at the North Andover School Administration Building at 566 Main Street, North Andover, Massachusetts, on Tuesday, February 9, 2016, at 7:30 p.m. to all parties interested in the petition for Smolak & Vaughn LLP and Andover Consultants, Inc. on behalf of Suzanne Wright, trustee of the Technical Training Foundation, also known as Technical Training Foundation Trust, for property located at 1665 Great Pond Road, map 62, parcel 19, North Andover, Massachusetts, 01845. The applicant is requesting a variance pursuant to section 4.136.3.C. Double Romanet I.3 for construction of a new permanent structure in the R1 zoning district. A variance is requested under section 4.136, Watershed Protection Division. 3, uses and building requirements. C, Romanet 2, 3, non-disturb. I can't make this up, everybody at home. Non-disturbance buffer zone of the zoning bylaws. Application and supporting materials are available for review at the office of the zoning department located at 1600 Osgood Street, North Andover, Massachusetts, Monday, Wednesday, and Thursday from the hours of 8 to 4, Tuesday from the hours of 8 to 5:30, and Friday from 8 to 11:30. So ends the reading, Mr. Chair.
All right, that was an outstanding job. Thanks for that. So, just to set the stage, I'm assuming that this is a multi-board jurisdictional project, that's the what, you need to be at the planning board,
We've actually filed already, and we've had them continue it pending resolution with
because
you.
their policy or procedures, they take no action until this board
Correct.
sets a footprint, and then you need to be at conservation as well?
Actually, we don't.
You don't, okay, so it's just the two boards.
Yes.
So we've had these in the past, these types of watershed protection waiver hearings. So can I just ask, is there a stormwater component that's part of the planning board process?
There is.
Okay,
It's actually in review right now with the planning board's peer engineer.
okay. All right, because that, historically, that sort of helps drive the thrust for the need of the variance, I think. Because my understanding was the plan, the construction plan may be different
Yes.
because you don't know what you want to build yet?
Right. So
So I don't want to, I'm just trying to,
yeah, this is a little bit of the history on this is obviously this is a little bit different than some of the ones that have come before you in the past because we already do have an existing structure. So by right, we could raise and rebuild on the same foundation.
all right,
As this has progressed, we think we can improve the project by actually getting rid of the foundation itself and slightly moving the footprint of the building. Under the bylaw, we need the variance for a new structure. Under the bylaw, you don't need a variance for a replacement of an existing structure. So the question that really came up as to whether or not we needed to be here was, is this or is this not a replacement of an existing structure, or is it in fact a new structure? And I'm just going to take one step over here. So, you know, you can see that it's the new proposed structure is located substantially in the same location, but in fact, it's being moved about 10 feet, I believe it is, closer to the roadway. We're going from 104 to 91 feet 4 inches. And the reason we're doing that is reconstruction is somewhat limited by the existing foundation because it's a split entry, and I think we can build a better home than we can on that existing foundation. And secondly, from a zoning perspective, we're actually able to eliminate some existing nonconformities by moving the structure, because you can see that we presently have a couple of pre-existing non-conforming setbacks, where the setback's 30 feet, and by sliding the foundation forward slightly on the lot, we're still able to we think, build a nicer home, eliminate the nonconformities in terms of dimensional side yard setbacks, and you know, still we've got to go through, as you mentioned earlier, the planning board process, which is going to make sure that we're protecting the aquifer.
so what, is their process a site plan review, or is it more than that, as it relates to what you want to do?
It's a watershed special permit.
It's a watershed special permit?
Yes.
Okay, so that's why they evaluate the stormwater in relation to the lake and
Correct.
that sort of thing. All Seward now, that part of town is all Seward.
Yes,
Has
this
been-
is on sewer.
Has been for years. So what's driving the need, for the project? What's driving the need to change the structure and the configuration?
Well, the applicant actually had a contractor look at rebuilding the house that was there. You know, if you've driven by the site, there's still the structure of a house there, but there would be so many things that you would have to do to bring it up to code, because you'd be improving more than 50% of the house, that it's really better, it's ecologically better, it's financially better to put a new house in. So one thought was to just put a new house on the foundation that's there, but we've got a foundation of unknown quantity and quality. We have a cellar floor slab that's not the best, and it really would be better just to replace the entire house. Well, if we are replacing the house, that's why we sited it where we did, because now we got rid of the non-conforming setbacks that were for the existing dwelling. And we're putting the house where it is so that we're able to use the same driveway. We're doing the least amount of disturbance on the site. So that's better, to have the least amount of disturbance when we're inside the watershed. And it's working with the topography that's there now. The front yard is about 8 feet lower, 7 feet lower than the backyard. So we're fitting the house in to the slope that's there, so that we're going to maintain the level backyard that's on the site now. And the house would have a garage under on the left-hand side, so we're using most of the driveway in the front, so we're not having any work at all being done within 100 feet of the lake. That's why we're actually not having to file with the Conservation Commission. So,
Oh, you're outside.
because we're outside the buffer zone. So
Right.
this plan allows the trust to build a new house, get rid of the old house, build a new house, more energy efficient, safer, all new mechanicals, et cetera, and have the least amount of disturbance on the site.
Is there a lot of mature tree growth and vegetation in terms of where you want to?
There isn't.
It's all open?
It's clear all around it.
Yeah, okay. And you want to build, I think I was told, a ranch? You're considering building a ranch home as opposed to a
No, this would be a two-story house.
two-story house?
Yeah.
What-
Just the design of the house hasn't been set yet, because they really don't want to go forward with spending thousands on architectural plans unless we know this project's going forward. And the real impact is the footprint. There's actually going to be less impervious cover on site with the new plan than with the existing conditions. Slightly less,
It looks
400 or
like-
500 square feet.
What is the Technical Training Foundation Trust? Is that something specific, or is it just a name? I'm a little...
It's actually, it's a nonprofit, and this house used to be the residence of Ibrahim El-Hefni, which was microwave research on Route 125.
Right.
And he bequeathed his estate basically to set up a nonprofit that provides educational opportunities. They actually just built a school in Windham, New Hampshire. The trust built and finished the Campion Hall condominium project, and all of the profits go to education. All of the profits from Campion Hall went to Notre Dame Academy.
Yeah, that rings a bell. I remember that.
In Lawrence. So
Yeah.
nobody's going to realize a profit from this. What the trust wants to do is to maximize their value, because the assets they have go to education.
So the use is to be a residential use for trust purposes?
No,
or-
what they'll do is they'll build the house and sell it,
Oh, I see.
and the profit goes to the trust, and they use the money for educational purposes.
Gotcha.
So it's not a for-profit endeavor here.
Okay.
But it will be just a normal residence. It's it's going to be just marketed and sold, and someone will buy it. And it's not as though it's subject to any kind of deed restriction or anything. It's just a residential home for an individual.
Gotcha. So is it sloped? I mean, what is the slope? I noticed there's a retaining wall on the proposed dwelling. I mean, how is the topography sort of interacting in terms of with what you're doing?
Well, as I said, the front yard here is about 7 feet lower than the backyard.
Oh,
So that retaining wall is basically to get from and this will be a garage on the house, so that retaining wall is just for grading in the front. There was one there before.
yeah.
The remnants of it was torn out about a year or two ago, the retaining wall and the front steps that went up to the first floor. So we're basically just mimicking that, just with new construction.
And the new construction seems to comply with all the setbacks,
It does.
so it's just the watershed component of
Correct.
what you want to do. Has there been any feedback from the planning board in terms of what you want to do here? I mean, usually, historically, I know they want a footprint set, and then it always gets a little challenging for us because, without seeing what you want to build, I know you want a footprint set, I know you don't want to spend a lot of money on doing any kind of construction, because then you get stuck between the two boards and going back and forth, and then what if they don't like the footprint, and then you got to come back. And so has there been any kind of feedback at all?
Just the peer review with a dozen comments or so that we'll address once we know your,
Yeah.
hopefully.
The
once we get
the
your
only
approval on this.
original, I guess, to the extent there was any feedback, it was just the intricacy that I'd mentioned about whether or not this was the replacement of an existing structure,
Yeah.
or whether it was, in fact, a new structure. We had filed there without filing here, under the belief that it was, in fact, a replacement, but because the foundation is being replaced as well, they wanted to make sure that you guys were okay with that.
And what's the stormwater component? Like, what do you expect to be peer reviewed here for stormwater for the?
Well, we supplied information as to the fact that we had less impervious cover, therefore less runoff, but we may be requested to put some infiltration in for the roof, maybe some infiltration on the side of the driveway, and we'll work that out with their peer review engineer,
Who are they using?
Eggleston.
Oh, okay. Well, she's the one that does the peer
Yeah,
review.
she does virtually everything that we've done in town.
Right. I think she reviewed the last one of these types of projects that we saw.
If this were to be approved today, what would be the basic of it? The unknown being the final design of the house, what's the basis for flexibility or adjustment to the footprint after this board kind of?
Yeah, I don't think we would have any change to the footprint, but I guess from a legal perspective, it would have to be compliant with all zoning, of course. Everything would be reviewed by the building inspector to issue the permits, and, if we were looking to do anything which, later, which required relief from this board, he'd send us right back here.
Right. I mean, the final footprint may have a jog here or there, a bay window sticking out, but it'll comply generally to that footprint. That's laid out so that there could be a 3-stall garage, because that seems to be what's driving new homes in this neighborhood right now. It's not too big because it doesn't really call for a McMansion-type house, but it's not a starter home either. And that footprint fits with the setbacks, and it fits with the scale of the, anticipated square footage of the
Well,
house.
that's a good size footprint. I mean, that's, that gives you some space in terms of, it's nice in terms of how it's set up on the lot, but it's definitely a good size. I mean, I think if we set a footprint, I think it's got to comply with the footprint, and then if there's a modification and you want to, if it changes, I think you got to come back for a modification in terms of, I think once it's set, it's kind of set, unless the planning board wants something changed too.
Right.
That's been my experience with this stuff anyway. You can always make it smaller, I suppose. I don't know if you can make it bigger.
No,
I don't anticipate the impervious roof cover to be bigger than this, that if anything, there may be some reductions, but it in all likelihood would not be bigger. We're kind of at the minimum setbacks with this layout. We've given ourselves an extra foot here and here. So there's only 1 foot to play on either side.
I mean, in theory, it could still conform with zoning setbacks if the house were to grow towards the street and towards the back. I mean, just throwing out the hypothetical.
right, but I think that to Al's point,
Yeah.
I think I would tend to agree that this is the plan that's getting recorded. This is the footprint we're authorized to build on, and the intent is, if this is approved, is to bring this to the architect and tell the architect, okay, now design on top of that.
You must have something in mind, right? I mean, I guess that's the struggle for me in these types of applications, is not the request for the waiver so much as the unknown as to what it's going to look like
I mean,
in the context of the waiver,
Mhm.
you know?
I feel like I've seen examples of these kinds of approvals before where there's almost a more generic building envelope, buildable area almost that could meet approval, which could be twice as large as this footprint, but it eliminates the specificity of, oh, there's a corner right here and a corner, because it's more of a generic kind of.
But it's driving the stormwater counts. So in terms of your impervious area,
Yeah, understood.
in what you're proposing,
As I
That's the
said,
basis for your period.
the impervious cover would be not larger than this. It might be less.
anybody have any other comments?
The existing structure vacant?
It is,
Yes.
yes.
It's been vacant for how long-ish?
That I don't have an answer on.
Well, more than a year.
More than a year, yes, I know that, more than a year.
I'm going to channel my inner Ms. McIntyre in deference to her absence. And you'll see immediately where I'm going. The size of the existing structure, the livable square footage, and the square footage anticipated. I mean, a quick calc suggests that there will be a 3,600 square foot home on this footprint. What exists there now?
Probably about the same, because it was a split level house where the basement was livable space, or the lower level, so it's approximately the same. It's actually, it's a large house that's there now.
It looks similar, but I can't do the math. You know, I mean, I guess my thoughts on this sort of thing is, to the extent the board were to set the footprint and send you off to planning, I still think, my comfort level still lies in you guys coming back for a second approval to show us what it is you want to build, in terms of the final thing. Even if it's part of even keeping the hearing open, saying we'd approve this type of footprint, go to planning board, or as a condition, some kind of condition that would have you coming back with a presentation of what the architecture's going to look like to comport with what was approved. So those are my thoughts on that, and maybe the board would disagree with it.
Well, if
We've
I
done that in
might-
the past, I'm pretty
If
sure.
I might just, they may be looking to build a house custom for somebody on this lot. And that may take, some effort to get an architect to design something specifically for a customer.
Yeah.
The impact to the town and zoning really isn't the placement of windows or the pitch of the roof. It's the roof area, it's the driveway area, and we
But I
would
don't
hope to...
we don't even have those calculations. I don't have the peer review to rely on in
Well, but-
terms of what is driving the variance.
Right. But what we've done here is we've taken something that's non-conforming and made it conforming as to setbacks.
I mean,
It is going to have a very detailed look by the planning board as far as drainage goes and impacts on the watershed and runoff.
I know, it's not your proposal, it's the process, because we're asked to set a footprint, but we don't know what it's going to look like. So we don't know the totality of the impact in terms of what we're approving. So, so you go to the planning board for a special permit as it relates to the watershed or the drainage. I don't know to what extent they're looking at the architectural component of that footprint that we set or not. And, I think that's where it gets tricky for us, at least for me. That's where it gets tricky for me.
That's not within our parameters to judge on, is it? I mean,
Well, I think
architectural character.
I think the board has broad discretion as it relates to the request for relief for the variance. In the past, we've also, with these types of projects, we've relied on the peer review that's come in as the basis to show that we should grant the watershed protection variance request, because we're not experts as it relates to that, but that's what we're being asked to vary. That's what we're being asked to waive, because we don't have it yet. You know, when's that going to be in?
Well, but that's really within the purview of the planning board, isn't it? That's what the special permit is
But the-
for the process of determining the stormwater calcs.
Then why
and-
do they
and
send you
such.
for a variance? If it's all
It's-
within the purview of the planning board, why are you here?
Because under the bylaw, it requires the waiver in advance, which
Sure.
it's kind of an odd bylaw provision. I'm not really aware of any other towns that do it this way, and it really kind of doesn't make sense. I agree
I
with
agree.
you on that.
I'd rather be giving you the variance after planning board has said, yeah, we like your project. But, so, I mean, I guess in terms of comfort level, I'm only one of five, but historically, with these types of projects, the way I've approached them is, you know, we'd want to have the peer review in to you know, as the basis to show, to augment the waiver request, because that's really the nexus, right? And then, as it relates to the footprint itself, we want to
Well-
see what you're building.
We did have one recently on Campion Road. It was a unique situation. It was in the watershed. There was a isolated wetland that came up, but the Zoning Board of Appeals granted relief, and then we went to Planning and Conservation for their approval after the fact.
Yeah, my recollection on that one was your decision, you had a condition within the decision that it was subject to the planning board review and approval, so that was how the board handled it in that case, at least.
I don't recollect that specifically. The ones that come to mind are all the ones that have been around the lake, you know, in terms of comparatively speaking, around the lake, you know, but, hey, you know, it's up to the board. I mean, I don't make the motions. I'm just voicing my thoughts in terms of the relief that you're asking for and the impact of a decision, so.
My thoughts are a little bit different, Mr. Chair, to the extent it's of any relevance to the board members.
Absolutely.
I find the bylaw to be similarly challenging. I think we all agree. None of us are here to necessarily challenge it. We're all here to work within the bylaw without unduly, I guess, burdening the applicants in this vortex of municipal management, board management. So where I am is that they're in front. They're just moving the footprint of the building, and that's kind of what I am focused on.
Mhm.
Knowing that my brothers and sisters on the planning board are I have to have faith. Maybe I shouldn't, but I have to have faith that my brothers and sisters on the planning board are going to give this more than a cursory look-see. Where I internally fall down, and I might look to you guys for a little bit of an education on this, because we don't necessarily see these every day, is you indicate that you don't have to go to the Concom, which comes as a surprise to me, mostly because I'm the biggest ignoramus on the board. I look at Lake Cochicowick is less than 200 feet away. There's a 100-foot buffer zone, and then I'm going to ask you what that means.
Certainly.
And then I'll ask you what the non-disturbance buffer zone means, and then there's a non-discharge buffer zone. So I'm interested in that stuff, which you've kind of foreshadowed already. And so I might ask you for the distinctions between the three of them, which are not necessarily important. They're just kind of helping me wrap my head around this. The important feature to me, no matter what your responses are to the three-tier or the three different zones, is you're staying within the same zone, by a lot, for heaven's sakes. I mean, you're not even going anywhere near the less intensive non-discharge zone, and you're not coming anywhere near the 100-foot buffer zone. So a lot of my concerns are assuaged because you're staying essentially within the same zone. You can correct my vocabulary on that if you just give me a little bit of an education on the three zones, what they mean, and why this
Sure.
doesn't end up in Concom's lap.
Let's start with the 100-foot buffer zone. The 100-foot buffer zone is a jurisdictional zone. So if you alter the ground anywhere within 100 feet of a wetland resource area, that could be a stream, a pond, a river, a lake, a dune, or the ocean, anything in Massachusetts you have to file with the Conservation Commission. So we're going to use the same water service, the same sewer service, and the driveway, all that's within that 100-foot buffer zone. So we're not going to alter the ground in the buffer zone. Purposely did that. We purposely decided, just so that we wouldn't have to go to the Conservation Commission. And we comply with the law. So if the law was worded such that if you're going to do work within 100 feet, then it's presumed that there's a possibility of harming the resource area. And if you're outside the 100 feet, it's presumed that you wouldn't harm the resource area. If for any reason you do, whether all our work was outside the 100 feet or not, the Conservation Commission can take jurisdiction. So the 100-foot buffer zone, we're outside it with any work, no alteration of the ground, so we don't have to file with them. The 250-foot non-disturbance zone is in the zoning bylaw. In this case, it applies to lots created prior to 1994. So because we're in the 250-foot non-disturbance zone, that's why we're here. So you're not supposed to disturb the ground within 250 feet of the lake. So we're here for that because it's impossible to do anything. You couldn't put a sidewalk a new sidewalk on the house without doing work in a 250-foot non-disturbance zone. The 325-foot non-discharge zone, the non-discharge zone has been in effect since back in the 80s, and that was meant that you wouldn't have a septic system. A septic system is a sewage discharge, or that you wouldn't have a drainage pipe from a subdivision dumping stormwater out of catch basins. That's a discharge also. So that's why that distance is even further back.
Because in those days, the sewer wasn't there.
There was
as
no
I recall.
sewer there, right. So
Right.
that's where the non-discharge zone came from. We have it on the plan because they're in the zoning bylaw. We've got the 250-foot non-disturb zone in the zoning bylaw, the 325-foot non-discharge zone. The 100-foot buffer zone is under the State Wetlands Protection Act and the town's wetlands bylaw.
Okay. And
Does that...
thank you. And one of the things that I heard you say, just stay out of the 100 foot so that you don't have to be managed by the CONCOM, which is a decision that I completely respect. You're far enough away from it as well. There's plenty of room to work with, it appears, anyway. What I heard you say is kind of a coda to that is if you end up having an effect, a negative effect on the resource, then somebody comes after you.
Then
How does that end up, I'm not saying it's
Sure.
happening on this
Yeah.
site,
Mhm.
but as a general premise, how do people discover that there's been an effect worth enforcing?
the biggest thing would be if, for example, when we go through our site plan review, we're showing them erosion control, how we're going to manage sediment and stockpiling on the site. Let's say the contractor was a slob, and a big storm's coming, and he's got a big pile of loam sitting in the driveway, and it washes down the driveway, and you've now got silt, visible silt in the buffer zone. Every conservation commission that I deal with in northeastern Massachusetts would give them an enforcement order and say, you're now in our jurisdiction. Sorry. File, and they'll put a stop work order on it, an enforcement order. And so when you're outside, it's an incentive to be very diligent in your work so that you don't have to go before the Conservation Commission.
Understood. All right, thank you for that.
Okay.
Well, I think we should just take note. I don't see, let the record reflect, there doesn't appear to be any abutters here to talk in favor or against the project. So is there any additional, is this something you'd like the board to act on tonight? Or is there anything additional you would wanted to submit, or?
No, I think we'd like to take action this evening.
All right. Well,
No further discussion from me, seems pretty straightforward.
You don't want the stormwater counts?
I have trust and faith in the planning board to address any of those concerns.
If I could just add, we've done quite a few watershed special permits. It's probably the most thorough review of anywhere that we go through for a single-family houses in North Andover.
Generally,
It's-
I like your project. I mean, I think it's a very positive one. I get stuck on what we're asked to do legally and, what we have, but, because you're asking for a variance for something that goes to another board.
Mhm.
So that's something that just, always sort of rubs me the wrong way. It's got nothing to do with your project. I think your project makes sense. I think it's a nice project. I would like to see what it's going to look like before there's a final blessing on it somehow by means of a condition, but, or you come back with a presentation to show us what's been approved. But the board may not do that. I think whatever the board is inclined to do at this point, would be appropriate. I don't know if there's any other feelings about it. I mean, it actually looks like, you have an existing dwelling that's not occupied. I don't know whether it's habitable or not. But what you're looking to do is very similar, from what I can tell, from the plans that you submitted. I just don't know what it's going to look like.
I can assure you it'll look better than what's there now.
Well, that's subjective. That depends on what you're going to build. But,
What I'm saying is that it's going to look like they address two existing non-conforming conditions.
it's going to look like this. This is what you submitted.
It's possible that it could look like that.
It's possible,
Possible, yeah.
not definite.
I didn't know that house plans were submitted with the
Well,
application.
those were Al, I know your concerns. The reason I submitted those plans is just to kind of at least give you guys some context as to the type of plan that this, applicant had already had prepared.
Yeah, I appreciate
And
it. I just can't, we can't unring the bell. If the board approves it, you can't unring the bell.
Right, and I can't guarantee, I don't want to say to the board, because I care about my reputation, I want to say, yeah, it's going to look like that, because, I don't know that for certain. I can tell you that it's going to comply with zoning. I'm going to tell you that the owner liked those plans and was okay with them, but wants to build something nicer than that, and would have the capacity and the ability to do that on this newer foundation. So, and also, I would be, more than happy to come back with plans and show them to you. It's just, I have a difficult time because of the way the process works, where, being able to proceed to the next thing and then never knowing the contingencies
But it's well within the board's authority to give you condition of final approval based on the final plans. We can approve, if we could set a footprint, we could send you to planning, do what you need to do at planning, and then come back to us for a final approval, because it's part of the decision. But your footprint's set, and then if anything changes, if there's any modifications, if anything gets moved, it's addressed. But it's up to the board. I'm not, those are just my thoughts on it, just in terms of the process as it exists today. I think generally it sounds like a very nice project. I have no doubt that you have a lot of hurdles to jump through. I have no doubt that, part of this bylaw was maybe driven before the sewer was there. I understand the framework. I think everybody here understands the framework. So it's just what they're comfortable with approving. That's all.
I do. I'm of a mind that I'd be more than happy to act tonight, be more than happy to add conditions. The conditions that I would be supportive of are conditions if we're talking about things that would generally be under the purview of the planning board and that will be addressed by the planning board. are things that I don't necessarily, speaking for myself, I don't necessarily need final approval over that. I am a guy who would absolutely love to know what happened. And so I would love to take, Attorney Vaughn's invitation to come back and basically show us what happened. And that way, I think that I would learn probably a very valuable lesson. Did my brothers and sisters on the planning board drop the ball that I expected them to carry? Or did they, carry the water that I expected them to carry? And so did we end up with a project that's kind of conforming with what I think I have in mind as far as the various peer review items and other things that we may be concerned with? But in this case, the prospect of this is a pretty narrow, to me, I boil it down for myself, making it simple, black and white. This is a zoning proposal. We've got improvements in setbacks and eliminating some pre-existing non-conforming stuff. We're going to end up with a better structure, presumably, something that's not dissimilar from what's there now as far as scale goes. So I see nothing but improvement in the future. On the other hand, these could be rosy-colored Pollyannish glasses that I'm looking at, which is why I think Attorney Vaughn coming back once they're done is something I'd be very interested in having as a condition. If, however, where I get a lot less tolerant, to kind of be provocative, I guess, is if this is the plan that we are approving and this is the plan that's being recorded, if we deviate from this plan, other than de minimis stuff, if you've got a bay window in there, I'm not real interested in a bay window. But if the foundation moves, I don't want to say more than an inch because that's really obnoxious, but if it moves, a foot or two, I guess, I would be interested in having another bite at this apple.
Mm-hmm. Well, look, I have a lot of respect for Attorney Vaughn and for Mr. McLeod and the work that they do. I don't, the only where I deviate from you is I don't feel the need for you to have to come back and give a report. The question is the board, either you're approving the foundation or you're not, either you're relying on the stormwater calculations or you're not, either we're conditioning another approval, a final approval, or we're not. I just think it's just whatever that comfort level is. You can always, do your diligence and find out what happens at another board, but I think the question is, do you want to sign off on a footprint as great as it sounds without knowing what it's ultimately going to look like? And if you're okay with that, then do it. I don't think you need to come back and give us a report, personally. I would only want you to come back because either you're looking for a modification or this board has reserved the right for a final approval. Because otherwise, I think it's sort of just a waste of time and money for your client. The question is, are you okay with not knowing what it's ultimately going to look like? That's what it comes down to.
Yeah. I am. I think it would be a greater waste of the client's time and money if we had the circularity of approvals. For them to have to come back to us at the end feels like a much greater waste. To have a pro forma, Attorney Vaughn come on in and show us a few pictures, let us know how it went on the record. Give us 15 minutes of what happened.
I think that's well within the board's discretion in terms of however you guys want to approve it.
Understood.
I would support that kind of dialogue at the end, but not needing a final approval. I think I'm comfortable with looking at the zoning issues here and the footprint and approving that for the zoning jurisdiction that we really have. And I would love to, as an architect, I would love to play designer and pretend, but I do that at work. I don't need to do that here. I don't think it's within our board's discretion to really get into what kind of cornice you have on the building, and as much as it's fun to talk about pretty pictures, that's not what we do. So if you, to your point.
It's not what we do, and this will be my last point. But they're here for a variance because they require a variance for what they want to do.
Mm-hmm.
And there is some case law about the discretion.
Oh, it's
The board has broad discretion.
lots
But
of discretion.
I respect the points of view, and I suggest, my only procedural suggestion to you is if that's where you're inclined to go, there is no abutters here tonight. And if you don't have anything else that you are inclined to submit, that you close the public hearing, you ask us to close it, and then you make a motion and deliberate in terms of whatever you want to do.
Sure.
I mean, that's my recommendation to you.
And I just, I mean, point of discussion, Al, it's just the way the way I've reconciled this bylaw for the issue that you seem to be hung up on is that what the variance really is all about is simply, can you build a residence here? And then, at least that's how I read the variance provision, and then the rest of the bylaws section to really speak towards the special permit at the planning board. And I think if you look at it that way, it could kind of get you over the hang-up of the water calcs and all that other stuff. And I mean, in this case in particular, I find it kind of interesting because it goes back to what I actually was originally speaking to, which was replacing versus a new structure. And, you know, it's kind of ironic that the variance we're looking for is in large part that we're improving by eliminating some of the other nonconformities. It's really saying, well, hey, can we put a building on this lot, which seems kind of absurd.
Yeah,
But-
I see your point. I mean, I respectfully just disagree with that because of the context of what we're asked to do. I've seen some projects over the years, you know, some haven't gone the way, not with you folks, but some things the board's approved in different parts of town haven't turned out the way we anticipated, even with the review, and then everybody's like, why did you approve that? You know, so I kind of have a hard time approving something that I don't know what it's going to look like personally. I like your project. I think it's a good project, but you know, it's not just me. You know, I mean, however, the board's comfortable with what you've said to them. So, you know, I would suggest that at this point you just sort of move it forward if that's what folks want to do.
Are you comfortable that this is going to stay where it's put on the plan? And you're pretty comfortable
Yeah.
with that?
Oh, location-wise, absolutely, yes.
Okay. Ledge, doesn't matter what you hit, you're going to fit it in here?
There's already a house pretty much in the same spot. We're just kind of sliding it forward a few feet, so we know that it's going to work.
And I mean, obviously, whatever conditions you guys put on it, you put on it. But I think we would be comfortable with the condition that, you know, it's you know, within that footprint, that it's if it were different than that it's smaller, it's not bigger, it's within the footprint as shown on the plan. And then, you know, if something happens where we need to alter that, then we're back before you.
Well, this is the plan you submitted. So this plan would be referenced in the decision.
Yes.
So you know, I mean, I would expect that if there's a deviation from the plan, you're coming in for a modification, and the board is going to determine if it's substantial or insubstantial, and what the change is, you know, if it gets that far. But it's a modification. I mean, I would view it within the year-and-a-half period as a modification. It wouldn't be a new public hearing if the board approves it, you know?
Yep, I would agree.
Because, all right. Are you comfortable with the board closing the public hearing?
Yes.
Okay.
I'll make a motion to close the public hearing.
Second.
Motion and a second, all in favor?
Aye.
Okay, hearing's closed. I'll hear a motion to approve and/or
I will
any
make
deliberation.
a motion to approve the variance as requested by the applicant, Suzanne Wright, trustee of the Technical Training Foundation, also known as Technical Training Foundation Trust, for the property located at 1665 Great Pond Road, map 62, parcel 19, North Andover, Mass. 01845. And as stated earlier, it's a motion to approve the variance pursuant to section 4.136.3.c, point Romanet 2.3, for construction of a new permanent structure in the R1 zoning district. And a variance requested under section 4.136, Watershed Protection Division, 3, uses and bylaw uses and building requirements, C, Romanet 2.3, non-disturbance buffer zone of the zoning bylaws. So that's a motion to approve those two variances with a couple of conditions as we discussed, one of which is upon approvals from any other boards of the town of North Andover to return to the Zoning Board of Appeals, just to kind of give an update, a narrative for how those things went, offer plans, pictures, drawings, whatever those things may be that were ultimately approved. And the second condition, which I think we probably don't even need to say out loud, but we'll say out loud anyway, is that in referring to and in citing in the decision a ZBA a plan titled ZBA Variance Plan 1665 Great Pond Road, North Andover, Massachusetts, owner prepared for Technical Training Foundation Trust. The date is January 13, 2016, scale 1 inches 20 feet, drawn by Andover Consultants, Inc. What I was saying is, if the dwelling is constructed on a foundation that is outside of the foundation as drawn in the plan referred to in the decision, that the applicant must return to the Zoning Board of Appeals for further final action and approval.
Can I just make one suggestion?
Absolutely.
If you want them, I don't think it's necessary for anybody to come back in the context of that motion. They could submit.
Sure.
They could just submit it.
Sure, submitting materials.
If you're not looking for a final approval, I don't think there's any need for anyone to come back.
That makes perfect sense, Mr. Chair.
Okay. So that'd be so amended.
So amended.
Is there a second to all of it?
I'll second that motion to approve both of the variances.
Okay.
As amended.
As
Or
amended.
as conditioned and
As
as
conditioned.
conditions amended.
As conditioned and amended.
Okay. And I'll
Did
call
you get all
it-
that, Merrill?
Right. Okay. Nice job. Nathan, you in favor?
Yes.
Denny?
Yes.
Paul?
Yes, sir.
Yes.
I will declare that approved, and I'll issue a decision within 14 days.
Thank you very much.
Thank you. Thank you, gentlemen.
Okay, and then just last on our agenda for tonight is the correspondence section. We just need approval of the correspondence and communications. It should have been on last month's agenda. I don't know why there wasn't. There was a letter from Attorney Caffrey as it related to Dr. Lentini's property, and a response that I had sent to that. There's been no hearings before our board as it relates to that property. I wasn't really sure what that was all about. And then we have a letter from, as it relates to Oak Ridge, Maple Reserve, and then community housing. So I would just hear a motion to approve the communications.
I'll make a motion to approve all three listed four listed communications.
Second.
All in favor?
Aye.
Okay, I'll declare those approved, and I'll hear a motion to close. Adjourn.
What's up, Denny? Denny, would you make a motion?
Put a motion into close.
Hey, motion by Denny. Is it a second?
Second.
And second, all in favor?
Aye.
Okay, we stand adjourned.